number 86, the matter of Black versus New York State Tax Appeals Tribunal. Counsel?
Chief Judge Wilson, members of the court, may it please the court. Chief Judge Wilson, may I reserve 5 minutes in a rebuttal?
5, yes.
This afternoon, I represent the petitioner, Christopher Black, who has brought this Article 78 proceeding challenging a determination of the tax tribunal, which found him 100% personally liable to pay the withholding taxes of New England Construction Company. Question before this court, a profoundly important question, which tax lawyers across the state are eager to hear what the court has to say, is whether or not the doctrine of federal conformity still exists at the Department of Tax and Finance. That doctrine simply holds.
Yeah, but it may exist, but the question is if the federal, if on the federal side you have a different record before you, right, the state has a more robust one, does that make a difference?
Well, Judge Rivera, that goes to the question of what deference should have been given to the IRS determination, which addressed the exact same issue, construing the federal analog to the
If you apply the appropriate factors, are you required to have the same result?
No. And our argument is not that the Department of Tax and Finance owed slavish deference to the IRS. That is not our argument.
Can you go back to the IRS point for a minute? Does the record reveal whether or not the holding out that Mr. Black did with respect to his status was before the IRS when it made its determination?
Well, there was holding out relative to the IRS, separate from the Department of Tax and Finance, which caused the IRS to conduct a parallel audit with the Department of Tax and Finance. But let me be clear, we're not arguing that the tax tribunal needed to simply rubber stamp the IRS's determination. We do argue, although it's not our primary argument, that at a minimum the IRS determination was not, as the tax tribunal said, irrelevant. The doctrine of federal...
Sorry, just if I could, counsel.
Please.
So there are a couple of forms in the record involving, it looks to me, a deferred payment agreement with the tax division. Were those specifically before the IRS when it made its determination? I just couldn't tell.
The record is silent on that. What we presented, and is part of your record, are those materials that we submitted to the IRS. What else the IRS had that caused them to trigger the audit, which incidentally initially sought $10 million in penalties as against my client, whereas the Department of Tax and Finance commenced their audit months after my client was fired by Anthony Nastasi at NECC. But my point about the doctrine of federal conformity, what makes this case important, is that when, as here, you have a state tax law, 685G, that is identical to a federal tax law, was drafted to conform word for word with the federal tax law on an important issue that amounts to an exception to the general rule that corporate officers are not personally liable, corporate employees are not personally liable. This is an exception to that rule. That when the law is identical, this court taught as far back as the 1970s in matter of Levin, that the state law and the federal law need not only to be conformed and interpreted the same way, but that the tax tribunal and New York court should be looking to federal law.
So where's
How
the
didn't they do that
error,
here?
counsel?
Sorry, Judge Cantorero.
No, go ahead.
How didn't that happen here? It appears to me that looking at sort of the totality of the circumstances, they were conforming to the federal statute.
Well, we know exactly what the tribunal did in this case and in other cases construing 685G, because their opinions are all online and you can look at them, and you can look at their 21-page opinion in this case. Unlike the more than 25 federal cases that we cited, they do not cite federal law. More, they don't cite the federal test. What is the federal test? Which they have never cited. And because this court has not addressed the meaning of 685G with respect to the personal responsibility issue, the tax tribunal has had a vacuum.
But if I'm understanding my colleague's question, the real issue is even if they don't cite those cases, even if they do not parrot the exact language in those cases, are they nevertheless indeed applying the same test?
Respectfully, Judge Rivera, they are clearly not.
Okay,
Why?
what's the test they're applying? And how is it different from the federal test?
Well, first of all, the State Tax Tribunal does not apply a test. They recite factors tethered to nothing. The federal cases, the Second Circuit, a mountain of case law, not hyperbole, says over and over again, the test, when is someone personally responsible? When they have effective power, actual ability, and authority to control the finances, that they write the check.
But isn't that just basically a shorthand summary that some circuit courts use for the myriad of factors test? I mean, the myriad of factors test really goes to that. So whether they sum up and say, okay, it goes to the phrasing you're just saying, or whether they apply the factors, I think to Judge Rivera's question, isn't it really the same thing, even if they don't have your tagline at the end? Some circuits don't use that tagline.
Most definitely not. It's not the tagline at the end, it's the test in the beginning.
But all those factors are the test. It seems hard to say you're misapplying a myriad of factors test, because they are looking at pretty much the same factors. They're just not summing up the way you're doing, or the way the circuit does.
Well, here, and again, if you look at your decisions in most of the Levin versus Gallen, and decisions which cite the federal case law and the federal test, which is robust, if you just recite a series of factors, you have, I know it when I see it, ad hoc decision-making. And that is what you had in this case.
Basic question, counsel, who is the burden here once they assess?
We had the burden of establishing that we would not be at the administrative hearing
Right.
before the tribunal. It was our burden, but our burden was entirely different than the one-paragraph analysis. That's what you got, 21-page decision with well, let me say this. Their whole argument to you, their whole argument is premised on two fictions. Let me start with this fiction. They would have you think that there was a credibility finding made by the tax tribunal. They say it over and over and over again in their brief. This isn't a metaphysical question. You have the decision of the tax tribunal, 21 pages long, 35 enumerated findings of fact. They did make factual findings of fact. Then they get to their analysis, and the tax tribunal sits like an appellate court. 3 commissioners with a record. They don't look at witnesses, they don't hear testimony. 1 paragraph, page 58, first paragraph. That is the sum total of their analysis. That 1 paragraph, if you look at it, has 3 errors in it. Error number 1, they framed the issue, and as Justice Lynch and as Justice Ahrens pointed out in their dissent, they framed the issue as whether petitioner presented facts showing petitioner lacked control and authority over the affairs of NECC, not the standard. It's not over the general business affairs. If that were the rule, then every corporate officer or employee, every director could potentially be liable. That's not the issue. It's whether they have control over the finances. Error number 1, you go to the final sentence. This is it. They come before the Court of Appeals and they represent to you there was a credibility finding. The final sentence, they say that is an implicit finding that the petitioner and the 3 witnesses...
So Mr. Black, in various documents that are in that record presented to the ALJ, represents that he has control over the finances, not just the company itself. But then he says otherwise. Isn't that, of course, a credibility determination? You've got to decide either the prior statements were true or the current statement is true. How would you otherwise reconcile it?
The tax tribunal, first of all, didn't make a factual finding. They drew a conclusion of law. They applied the...
But again, isn't that the exercise that one would have to go through? You've made statements before, conceding, right?
Yes.
That you have control, and now you want us to believe that you didn't have control. So you've got to make a decision. You're either believing the initial statements or this later statement that benefits, right, in the moment, the individual because they're trying to avoid paying the tax.
Well, let's presuppose that that is what the tribunal should have done. They didn't do it. The final sentence that they say represents a credibility finding is an application of the substantial evidence.
Let me ask you this, counsel. What is the public policy consequence, if any, of allowing people to file representations with the Department of Taxation and then several years later disprove them? And let's suppose they could prove that what they had done was false. What's the public policy consequence there?
There is a whole regulatory regime administered by the Department of Economic Development that addresses circumstances where a minority-owned business...
Forget about a minority-owned business. I'm not asking that at all. I mean, suppose this hadn't involved minority-owned businesses at all. It's just there are forms that you can make representations to the tax department that you are the responsible person for the purpose of collecting taxes. And those forms, I assume, are meant to induce governmental reliance.
Justice Lynch and Justice Ahrens addressed that point and made it clear that there are laws. First of all, the Department of Tax and Finance could have made a referral if they thought there was fraud to a law enforcement agency. They also could have, if they wanted to, made a referral to the Department of Economic Development to try to get NECC decertified. What they can't do is to distort and twist and contort 685G. Every commentator that has looked at this case, everyone knows what happened here. Everyone knows. It's not up for grabs. We know what happened here. The petitioner in this case, desperate to be able to maintain certification as an MBE, made...
Well, that is his sympathetic story. That's what I'm saying. You've got whatever narratives are going. But let me ask you a different question. I know your red
Please.
light is on, Chief Judge's permission. Do you agree that there could be more than one person responsible for the taxes?
Yes.
Does that matter here then?
No, because if you apply effective power, actual authority, and control, here is the undisputed evidence, if I might, the undisputed evidence. We called 4 witnesses, not a one of whom, and you can see the transcript, had their integrity questioned, was there any claims that they were testifying perjuriously. The undisputed evidence showed as follows. The petitioner in this case did not have control over the checkbook. That was in a safe in Hopog 40 miles away from him. Did not have the...
But yet he did sign checks.
What's that?
He did sign checks. So
He
again,
did.
we're back to either you believe his narrative or you don't.
He did.
Can I ask one question, Chief?
course.
So suppose we agree with you and we think the tribunal applied the wrong standard. What's the remedy? It goes back to the tribunal to apply the right standard?
That would be an option that the court would have. I think it's critically important in this case, given the 40-year vacuum that has been filled by the tax tribunal, to say what they think the standard is, never citing any federal law. First of all, to set forth, like Justice Lynch and Ahrens did, and by the way, they weren't stretching to say what the law is. They were merely reciting the federal cases. The tribunal needs to know what the standard is and actually articulate it in its decisions. If you wanted to, you could remit it and say, take a look under that standard, but I would suggest to you on this record, when you know the tribunal did not question the veracity, did not. You have the record before you. They didn't question the veracity of petitioner or any of the witnesses. They relied entirely on the documents and they said, here's what they said, that's sufficient. But that is not the law. There is a factual determination that needs to be made. Did the petitioner have effective actual power? Do you think he could have told Anthony Nastasi, you need to write checks to the Department of Tax and Finance? The undisputed record evidence is that he, the controller, the general counsel of NECC, multiple times went to Anthony Nastasi and said, pay the taxes. Nastasi said no. So in any event, if I might, I've reserved some time for a rebuttal.
Thank you.
Thank you.
May it please the court, hello, Your Honors, Owen DeMuth on behalf of the respondent commissioner. I made a little list here while I heard counsel argue. Judge Halligan, I'd like to answer your question. You had asked what was in the record, what was actually submitted to the IRS. We actually do know what was in the record, and we know this from petitioner's accountant who testified, who represented him during the appeal of the IRS. On page 340, he indicated that the total package was, it was basically 3 affidavits, an affidavit from petitioner, an affidavit from Mr. Nastasi, and an affidavit from the accountant, and apparently some bank signature cards. And those are on pages 802 to 818 of the record. That was, as Mr. Blanch indicated, the complete package of documents. Meanwhile, the tribunal has far more than that. It has an array of documents. The responsible person questionnaire, again,
With
indicating...
respect to the 2005 agreement between the parties, what role, if any, does that play with respect to actual or apparent authority?
It doesn't speak to it, and I'd like to thank you for asking. I'd like to make a few points about that. First of all, I would agree that because it provides for a future contingent transfer between Mr. Sasi's company and petitioner, it does indicate, of course, that Mr. Sasi had some influence over NECC. But to the extent it shows his control, it doesn't overcome substantial evidence, because ultimately that is the standard that applies here, indicating that petitioner also had and exercised his own control. And Judge Rivera, it is critical that both the federal and the state standards recognize that more than one person may be responsible. It's not the most responsible person. It's
So is
any...
it actual authority or is it apparent authority?
It's actual authority. And again, I think this was another question you asked, Judge Rivera. You said, does it matter? One of petitioner's arguments is that because the tribunal, and I guess some of the state cases don't use the exact phrasing that we see in some, not all of the federal cases, effective power, significant control, actual authority, then that means they apply the wrong standard.
With respect to financial control or authority,
Yes.
what role does that play?
Oh, it's still very important. That's not in dispute. But the fact that they didn't use phrases like effective power doesn't mean the tribunal did not consider that. And counsel indicates this, I'm sorry.
I was just going to ask, do you agree that the touchstone is financial control specifically and not broader operational control over a business?
Well, if you under this totality of circumstances analysis, which does make operational control relevant, emphasis, though, should be given to financial control.
So you think you think that the Federal Circuit Court case, which describes the core question as financial control, is a fair characterization of the test? I understand you're also saying...
They don't have to say it exactly that way. Yeah, no, I would agree with that, and I think the tribunal adhered to that, and counsel here indicates that the decision was a cursory one paragraph. It really isn't, because you have to look at the findings of fact. Pages 45 to 49 in the tribunal's decision lay out all the different facts.
Counsel, on that point, and I think one thing some of these questions have been going to, which seems to me to make this case different, are the representations that this person made in terms of control. How would you characterize the tribunal's findings with respect to those representations?
The tribunal found, and in this regard, it is a little different from what the LJ found. If you read the LJ's decision...
No, let's stick with the tribunal.
Okay. The tribunal found that and I think you mean representations, he wasn't just holding himself out without actual authority. The tribunal actually went further and said no. And the reason why we know this is because on page 58, this is all caught up in the credibility.
My bottom line is, are they saying, in your view, the tribunal, that you did this and we take you at your word, you're the responsible person here because that's how you represented it yourself to us and that's how we dealt with you in the past? Or are they saying you're basically stopped and we understand you weren't, but you said you were, so now, you're the responsible person anyway? Which of those
I don't think it's saying...
Or something else?
I think it's saying something else. I think it's saying, and we know this, what they did on page 58, petitioner's whole argument, contrary to what counsel said, is I had no control, Nastasi had complete, and if you want to quote...
So do they believe that or do they not believe it?
They kind of split the difference. What the tribunal found was, we agree Mr. Stasi seemed to have some influence, but of course, more than one responsible person doesn't prevent you from going after another one. What the tribunal found was whatever control Mr. Nastasi might have had, you yourself, petitioner, had and exercised enough actual authority of your own, and then cited all of these different things, including, I'd like to call the court's attention to there's a contact log between the department and petitioner on pages 784, 793, in which there are numerous communications during the period at issue between petitioner and the department, and not one reference to Mr. Nastasi, not one reference to him saying, I have to go back to Nastasi to get approval, I'm acting as an agent for him. It's petitioner who is carrying the ball and promising to make payments and promising to get financing for NECC. That and about 11 other sets of documents
So would you say, well, it might have been, they took it as it might have been an exaggeration in order to get certain advantages under this program, but it wasn't without basis?
Exactly. Petitioner's argument, it's an unusual argument a petitioner has to make, is everything I did was a sham. It was a fraud. I was being, I was really, this guy was pulling my strings. And the tribunal said, no, we're looking at these documents here. We're looking how you used these documents, and we think you had some authority on your own. So
is that the credibility determination that the tribunal is talking about?
It's absolutely.
Your adversary says it's not that. That's not the credibility determination.
It is a credibility determination.
And you're at page 58. That's
Yes.
the operative, that middle paragraph.
That's the
there.
most important part of the opinion, and I'm going to slightly paraphrase what they said, which shows that this is manifestly a credibility determination. Quote, we do not find petitioner's testimony that he never had authority or control over NECC overcomes the record evidence demonstrating just the opposite. This is credibility, and because it is...
If I could just confirm, you're saying that that credibility determination, or at least the fullness of that, was not before the IRS when they considered the claims made in this case?
Apparently not. All we have is their own affidavits and some bank signature cards.
I'm trying to figure out if maybe it's possible the IRS might have come to the same conclusion had they had the benefit of the same record.
I don't know, but it's clear that they didn't. It's clear that these were decided on very, very different records. And because of that, I think petitioner realizes that estoppel would not apply, but comedy shouldn't apply either.
Well, it's just, I think what your adversary is arguing is the reason why you might have different results here is that there's an inappropriate deviation from the focus on financial control on your side that the IRS is correctly applying, and that's the explanation for the divergence.
Well,
and I'm wondering if there are alternative explanations other than that.
Well, the bottom line is we'll never know. We don't know what the IRS determined. Not only was it a different record, but their letter...
But what in the record here establishes that the appropriate standard was applied below?
By the tribunal?
Yes.
As I was saying earlier, they first of all, they said it in a different way, but of course that doesn't render what they did wrong. They said it's a key factor in responsible person inquiries consider the involvement in fiscal matters. That's on page 57. And then, again, the findings of fact are part of the decision.
But not all persons involved in fiscal matters, there is, one could have some fiscal control, but not necessarily actual authority to make decisions as to who gets paid, when they get paid, what bills get paid.
Well, the tribunal found that there was actual, so whatever Nastasi himself also exercised, the tribunal found that there was.
So what in the record supports that he had actual authority to make those financial decisions as to who gets paid, when they get paid, et cetera?
Well, first, I'll go through it all. He had the authority to, and he submitted NECC's tax return as NECC's president. He had the authority to and did resolve disputes as the sole negotiator with the department in negotiating NECC's various tax liabilities.
But I said the overall financial responsibilities. Where is it that?
Well, I would say the best place to look is probably the responsible person questionnaire, where petitioner himself said, I have control over all financial affairs dealing with NECC.
And how does that avoid a titular head kind of situation? If you just look at that, can't you just default to the person being a titular head?
Oh, I don't think so at all, Your Honor. This is not just him saying, I'm the president, therefore I'm the guy. This is him saying, I'm the president, but I'm also, and it's more than just that. There's all these different boxes he's checking saying, I'm also responsible for this. Yeah, no, that's another error petitioner makes.
The core question, I thought you were arguing, and I thought they were arguing, that the core question is whether or not the individual who is being charged as the person responsible for paying the taxes is someone who, in fact, could have done that, but chose not to do that. But that's really the question that's
Well,
on
that's the
table.
willfulness part. The responsible person says, well, what actual authority did you have? And that goes to the 12 sets of
Yeah, but the
documents.
authority has to be to actually pay the taxes.
Right, and he did. I mean, again, look at that contact log on pages 784 to 793. He and he alone, no reference to Mr. Stassi at all, is saying, I'm going to try to get payment next time. Oh, I couldn't make payment this week, I had to make payroll. So he's also in charge of payroll,
And he
apparently.
does sign some checks.
And he's signing checks. And yes, petitioner made a lot about this was, you had to go down to Anastasi's office, but one thing that petitioner doesn't note is that the bank signature card on file at the time indicated that petitioner is signer number one and the only one of the two who had power to independently withdraw money.
Our
Wouldn't it have
review-
been easier for us to figure out that the appropriate standard was applied if federal law was cited? Is there a reason why they wouldn't cite federal law?
I suppose it would be easier, but I don't know of any requirement or any state case where if the issue before you is to parse a state tax law, you're all of a sudden required to then go out and do a
As it
parallel.
applies to conformity. So does conformity apply here or not?
Well, the issue was raised. We think it's meritless and a red herring. But yes, there was complete conformity here, and it doesn't matter that the language the tribunal used was slightly different. The standards are the same, and they
Counsel,
were
put it-
applied the same.
Put aside the test for a second and the conformity issue, and I understand the dispute, but assuming the right test, what's our standard of review of this record for the conclusion here?
Your standard is substantial evidence. That has been our argument all along, is that this was a fact-intensive, credibility-driven inquiry. They could not, when petitioner is putting his credibility at issue and making the argument that I had no control and Nastasi had exclusive control, it's clear that the tribunal did not accept that. That's a credibility determination, because
There's
it is.
substantial evidence based on the proper interpretation and application of the law, correct? So you have to have the correct standard in place.
Right, so the court would first say, just like the third department majority said, that there was no conflict, there was no inconsistency with how the tribunal applied 685 versus how the federal courts apply 6672. Then, I mean, that's kind of what this court did in 11 v. Goldman. It had, it's kind of a hybrid. There's an error of law, and the question that Levin had to address was, well, what does willfulness mean? Because this is back in many years ago. They adopted the federal standard, then they applied it to the substantial evidence review. So that's what this court could do here.
That also assumes, I take it, that we read that paragraph on page 58 as reflecting a credibility finding.
Yes, but even if you found that credibility, it's still substantial evidence. I mean, even if credibility didn't enter into it, I think that was nothing if not a credibility finding. It's still, as this court has said many times, probably most recently in Hague, you can have substantial evidence on either side. And so you can just do a weighing.
Just to make sure I understand, what I took you to be arguing, and maybe I misunderstood, was that to the extent there is evidence that he lacked any actual authority over the financial operations, that given that he had some operational control, was involved in the finances, and held himself out, that was enough to show that the tribunal must have found that the evidence cutting the other way was
Right.
not sufficient.
Right, and that's exactly what they
Which I
said on
took to
page
be-
58. We've considered your evidence that, he had witnesses, but that's how it goes, that's how it happens with substantial evidence review. Because there's contrary evidence, it doesn't change, it doesn't require annulment. And that's exactly what they did in 58. They said, we've considered your evidence, petitioner, but we also have all this other evidence, your own testimony, all these documents that you were paying taxes, that you were spearheading negotiations with the department, and it demonstrates just the opposite of what you're arguing. So yeah, that is a classic, even though the facts may be kind of odd, this is a classic substantial evidence case.
But that can't be what we're here to do. We're not here to determine whether or not there was substantial evidence. That's a fairly easy determination. The underlying issue is, did they apply did they test under the appropriate standard? That has to be the core of the argument, don't you
Well,
think?
that's the core of petitioner's argument, because he's trying to get around substantial evidence review. He knows he loses if substantial evidence review is the only issue before the court. But yes, that there is that error of law that he's raised. We've addressed it. And there is, we've gone into the federal cases that they've not pointed out any major departure. Even though the wording, the phrasing the tribunal used might have been different, it doesn't indicate that they weren't also giving strong credence and emphasis on his financial control over NECC. I mean, the standards are the same, and they were applied the same.
Thank you, counsel.
Thank you very much.
Mr. Greenberg, can I ask you a question?
Please.
It can't be the case that the tribunal or the appellate division has to cite the appropriate federal case that applies the correct standard just to prove that they're doing it right. I mean, they could cite their own precedent that shows that they're in conformity with the federal standard, can't they?
Yes, I
And I
don't
feel like
disagree.
that's what the appellate division did here. They cited their own precedent, but that precedent actually refers to what I think is the correct federal analysis.
Appellate division majority, when you read their opinion, they cite a 40-year-old case, and they articulate what they think the standard is in one sentence. That is not the federal standard. The trapdoor fell out from under their argument when Judge Halligan and Judge Troutman asked the
Is
question.
old law bad law? Is that the problem?
I'm sorry?
Is old law bad law?
No.
You're
it's-
talking about Tully, right? Is
no,
that the
The
40-year-old
one
case?
sentence in the appellate division majority is the same error of the tribunal. It's one sentence. It says the test are factors. Judge Halligan, you asked the question. At long last, they finally conceded what they resisted even in the appellate division, that the test is effective actual authority. The core inquiry is, does the person have the ability to decide the money can be paid? Your question, Judge Troutman.
Yeah, but that's the question. So you look at multiple factors, that's the way you answer that question, that's your test. So I'm not understanding your distinction.
Well, then, look, I want to be clear, crystal clear as the federal cases are. The core inquiry is whether or not the person at issue has effective power, actual authority, or ability over the finances of the company to cut the check, not sign the check. That is the core inquiry. And Judge Troutman, you put your finger on it. What does that 2005 agreement mean? Again, we don't have to speculate about what it means any more than the wild speculations about what they think the tribunal thought and did. The 2005 agreement says that Mr. Black was an at-will employee who could be fired in the unilateral determination of Anthony Nastasi, and he gets the whopping $26.
Counsel,
Hold
then
on, it
was you...
it doesn't actually say that, I think, at least not as I read it. I read it more as a security agreement. That is, Nastasi had loaned $4 million plus to the company, and what he put in place was a trigger where he could then acquire control of the company, and at that point, if the company was worth more than whatever amount of money he had loaned, plus whatever the secured creditors were owed, then the company would revert back to Mr. Black. If it was worth less than the sum of those two amounts, then it wouldn't revert back to Mr. Black. So it's a little, it's unclear, I think, at the time they sign it, whether the company is going to have more than the amount loaned plus the secured creditors, what was owed to them. So I think you're oversimplifying the way it worked.
Respectfully, I don't think I am. February 18, 2015, when Mr. Black would not assent to Anthony Nastasi's demand that he accept personal liability for the debts, right? February 18, 2015, he says, then you're done. That's the email. You're fired. Invoking the agreement, you're fired. And Mr. Black gets $26. That was the value of his stock, $26.
Right, but if the company actually had assets that were more than the sum of those two amounts, then Nastasi would be forced to sell back 70 shares for $70, right?
Yes,
That's the way the
theoretically.
agreement read. Well, it just depended on a future contingent event that nobody knew, at least I didn't know what the outcome would be. Maybe Nastasi did.
Well, I think a fair reading of the agreement, Your Honor, makes absolutely clear he's an at-will employee. He can be fired whenever Mr. Nastasi
And does
says.
that go just to the myriad of factors that you say we shouldn't consider him an owner? Because an at-will employee can still be a responsible person, right?
Yes, theoretically, they could be. But here's the reality. And incidentally, Judge Garcia, you asked a question. Like, what's really going on with the tribunal? Not wild speculations about credibility findings, which they clearly did not make. The one sentence says what it says. The tribunal struggled the same way I was in the appellate division, right, which is your point. They wanted to stop Mr. Black because of the forms he submitted. That's what's going on. It was a result in search of a
Can they do that?
rationale. It was a result.
Can they do that? Can they stop him? Why couldn't they say, we weighed this factor very heavily, you represented it to us, you got very lucrative contracts under this, we paid you all this money, you didn't withhold it, you told us that you would, you told us you were a responsible officer, and now you are, and we're holding you responsible. You can tell us the thing was in the drawer, or, you can make all those arguments, but you told us that, and now we're holding you to it. Can they do that?
I don't think they can do that under the federal standard. Perhaps,
I haven't seen a federal case where this has happened, and also can New York weigh it more heavily because the misrepresentations were made in a state program?
we could speculate what the tribunal might have done, could have done, should have done, would have thought, but you know what they did. And what they did, and by the way, before we got to the appellate division, the tax department fought bitterly the idea that actual authority was the test. Bitterly. It was only in the appellate division when finally, at long last, appeals and opinions had to concede what the federal standard was, and then said, yes, it's actual authority, but that's really what they were doing. You not only need to look at this opinion, but you have years and years of tax tribunal decisions where over and over again, never not once, have they applied anything like the federal standard.
Chief, may I ask one last question? To go back to the point you just made in response to Judge Garcia's question about whether they can do it, the only federal case I saw that shed any light on the question is one that both you and your adversary cite, which is Hochstein. And as the AG's office points out, I think there's a footnote in Hochstein which suggests that holding out is something that could be given significant weight. Are there any other federal cases you're aware of that address that point?
This particular fact pattern, the answer to Judge Halligan is no. I wasn't
You
able to
hold
find.
out as
I
being
wasn't-
responsible.
This fact pattern in its own right, I would suggest, is different, it's unique, and that's why I think Judge Lynch and Judge Aaron's got it exactly right. Are we going to warp and distort the tax tribunal's application of a provision, which, by the way, if I might make this one point,
Can I ask you this, again, with the Chief Judge's
course.
permission? Assume for one moment we disagree with you that there wasn't a credibility decision. If there is a credibility decision, does that then resolve the case in favor of the tribunal?
it does not.
Why not?
Because of this court's decision in 2014 in matter of Gayed and also the New York Times case. There is a threshold issue. Did the agency or did it not apply the correct standard? If you find that they applied the incorrect standard, which I think clearly they didn't apply the federal standard, then you don't
We
even get to
disagree
it.
with you on that. Those are the two things we need to do?
I believe the threshold issue, yes. First and foremost, did they apply the correct standard? And the final point I'd like to make is how vitally important to corporations all throughout the state of New York this case is and what the standard is. Why? Because every corporation in New York State takes withholding taxes from employees. Every corporation in New York State has officers and directors who do not want to be personally liable. And if they're going to be personally liable, they want to know when and under what circumstances.
Hopefully, they're not misrepresenting, right? I mean, that's what makes the case different, right? It's the
Whether-
concession, the admission that I have misrepresented my status, my ability to, as you say, cut, not sign the checks. That's what makes this different. I would hope that people are not on pins and needles over that.
Whatever the facts of this case are, the reason why it is in the New York Court of Appeals, there's a reason why this case is in the New York Court of Appeals, because Justice Lynch and Justice Aaron's thought after 40 years of a vacuum in the tribunal without any guidance from this court about the meaning of this test, that the tribunal once and for all should be told what the law is and to apply it. And for all of the reasons in our brief, we would respectfully request that you reverse. Thank you for your time and attention.